Hello, and welcome to another installment of White and Williams SubroSessions. I'm Joe Kuffler, counsel in our property subrogation department. And because we had such a good time doing the episode on the statute of repose together 2 months ago, we've gotten the band back together, and I'm joined once again by my colleague Gus Sara, who's a partner in the department. Hello, Gus. How are you doing today?
Hello, everyone. Thank you for joining.
Today, we're going to talk about issues and obstacles to subrogation commonly found in contracts. In the context of subrogation claims, you run into a wide variety of contracts, whether it's construction for new buildings, renovation projects, repairs to roofs or some other part of the building. There are also preventative maintenance and service contracts, like you have with HVAC systems or fire sprinkler systems, or IT and cybersecurity. You always also have rental and lease agreements and condominium documents. But the important thing to remember is no matter what type of contract you're dealing with, the single most important thing I can tell you is that you have to read the contract. If you get nothing else from this podcast, if you just remember that point, you'll at least be headed in the right direction. So before we start diving into the details of any specific contractual provisions, Gus, why don't you give us an overview of the types of provisions we're going to be discussing today?
Like Joe said, reading the contract from soup to nuts, first page to last, is critical. But we're going to hone in on some key provisions that tend to keep us up at night as subrogation professionals. And these provisions are subrogation waivers, limitation of liability and damages caps, accelerated statute of limitations, indemnification hold harmless provisions we'll be addressing briefly, notice and pre-suit requirements, venue forum clauses we'll also touch on, and arbitration clauses will be the final provision that we briefly discuss. Moving right into subrogation waivers. This is probably the most prevalent of the exculpatory provisions that we're going to be dealing with. It's directly related to what we do, and it crushes our dreams whenever we find good liability. Construction contracts, especially large ones involving commercial entities, typically have terms and conditions that contain subrogation waivers. There are a lot of customized construction contracts out there, but there's also a lot of construction projects that rely on the AIA contract template. The AIA is the American Institute of Architects. It was founded in 1857. It is an association that protects the interests of architects. And over the years, they developed a construction template that is now used by also general contractors, engineers, and subs. The main construction contract is A101, which is typically between the property owner and the general contractor, and also names the architect. That document incorporates another document, the A201 General Terms and Conditions. That document includes a big, fat, and very, very good, well-written subrogation waiver. It has seen many transformations over the years. The 2017 version is quite ironclad. It is, the result of years and years of litigating the previous versions of the subrogation waiver. Initial versions of the subrogation waiver would protect subcontractors but be related to the work as defined by the contract. And there was a slew of litigation that argued that any damage to property that wasn't a part of the work was not included in the subrogation waiver. And some states bought that argument. While it was a minority view, it was a good argument to make anytime you were confronted with a pre-2017 subrogation waiver. And there still may be losses that we receive that involve pre-2017 versions of the AIA contract. So you certainly want to be aware of that. If you come across the older versions of that provision, then that's an argument you may want to consider. The newer version gets away with that language and applies the provision generally abroad to any damage that occurs during the project. And this version seems to be a lot more clear, less ambiguous, and less open to interpretation arguments, such as, it's limited to when the work was performed or the property that comprises of the work itself. What are potential counter arguments? Obviously, the work argument for the pre 2017 is certainly one you want to make. Probably less applicable to the 2017 version. Does negligence, gross negligence, overcome the enforcement of a subrogation waiver? Some states allow gross negligence or showing of gross negligence to render limitations of liability unenforceable. However, there are a lot in my experience, most states do not allow gross negligence to render or to overcome a subrogation waiver. And there was a case, United National Insurance Co. versus Peninsula Roofing, a Fourth Circuit Court of Appeals case regarding a construction loss in Maryland. The court ruled that gross negligence does not overcome subrogation waivers. It also ruled that an argument that there was a breach of contract did not invalidate the application of the subrogation waiver. Certainly arguments you want to try to make. I've made them, but you got to check the law in that state to see if you will succeed on those arguments. Is the document signed? Certainly, again, another argument that you want to make, if you only can locate an unsigned document and there's no evidence that the document was ever executed, you can certainly make the argument that it's not a valid contract. However, the commencement of performance without a written contract can be considered acceptable if either side begins the work. So a court can very easily find that if the parties begin the work, that there was a mutual assent on the terms of the contract, and they'll likely be enforced. So again, an argument you might want to make, but don't get your hopes up.
Even if your loss or the construction takes place after 2017, you should still look at the contract to make sure they're actually using the 2017 form. That, we found sometimes construction projects, for whatever reason, they haven't paid for the updated form or whatever, are on an old 2004 form, even though the construction was in 2018 or something. So just because, you can't just go by the date of the loss and assume that that's the form that's going to apply. You'll see the contract and it'll say right on the front 2017 version or whatever. Gus alluded to this point, but that these AIA contracts are customizable. So you have to make sure to get a copy of the 201 to make sure that it's not just the standard terms applying. Like, you don't, as soon as you see there's an AIA contract, you don't have to just throw up your hands and say, okay, we lose, because it might have been changed and customized by the parties. For example, I'm currently dealing with a case where a contractor was doing repair work to a roof at a school under an AIA contract. The 201 Subro waiver, that provision was completely crossed out, and the parties put in their own language. And in that language, it says subrogation is waived for claims by the contractor against the owner, but it doesn't say anything about subrogation claims being waived in the case of claims of the owner against the contractor. So since we insured the school, or the owner in this case, I'm taking the position that, hey, there's no waiver and, we're good to go. So that wraps up our discussion on the construction contracts and the Subro waivers. Now we have a similar issue, but slightly different: limitations of liability and damages caps. These provisions, they don't waive subrogation outright, but it limits the sort of claims you can recover, the sort of causes of action you can recover for, or puts a monetary cap on any recovery. You frequently see these in service agreements. I do a lot of work with cyber claims, such as when a business gets hit by ransomware. And frequently you'll have limitations of liability and damages caps in contracts if the company has an outside IT provider, or you also have them in the license agreements with software providers that provide, antivirus software, or the programs that allow the employees to access the business's network remotely. And sometimes those will have vulnerabilities that the hackers get through. And in these cases, the limitations you often see: first, it bars recovery for indirect or consequential damages, which, is a completely vague term that courts have really struggled to define, and it's basically defined as whatever the judge feels like it means what the judge feels like it means that day. It's easy to say that if you have to replace servers that, were affected by the ransomware attack, that seems like direct damages. But what about if you're a hospital and the hacker potentially compromised the confidential information of 500,000 patients, and you, as the hospital, are required by statute to send out notices to 500,000 different former patients? Those costs add up quickly. Is that a direct damage or is that a consequential damage? You can argue it obviously either way, and courts, depending on the day of the week, have found either way. There's an issue that we run into frequently in these cases where there's a large lost profit business interruption component of the damages as you get your business back up to speed after your computers have been, your network's been shut down. And a lot of these limitations will specifically say, barring recovery for indirect or consequential damages, including but not limited to lost profits, business interruption. So in that case, you're kind of out of luck, even if you otherwise have a good claim for liability. And that then brings us into the issue with damages caps, where they'll have the limitation on what you can pursue. And then even if you do succeed, they say your damages are limited to, frequently it'll talk about, either 3 months or 12 months for how much you paid for the service or the software license, which ends up being, kind of peanuts compared to the size of the loss. So when we're faced with these obstacles, we like to try to consider ways to get around them because otherwise there's nowhere for us to go. So one argument is, well, was this party grossly negligent? Um, Gross negligence is a difficult burden to meet. I don't make that argument often, but every now and then the facts justify it. For instance, I had a claim where I was able to get a settlement in excess of the damages cap where the outside IT company, I don't know how it happened, but they removed all of the antivirus protection from the insured's network. And surprise, surprise, within a day, they got hit by a ransomware. You can also try to argue, if the limitation is overreaching so that it essentially constitutes a failure of the essential purpose of the contract. I sometimes try to make that argument with antivirus software agreements, saying that, you can't make where any claim for damages arising from a virus on your system is barred. And, the response is, well, then what is the contract for? I have no other remedy. There's nothing else I can do. That's what I contracted with you to provide. So again, kind of that's depends on your jurisdiction. You'll have varying degrees of success with that argument, but certainly something to keep in mind. And then one last issue is, the end user license agreement with the software. These are the things you've seen, 1,000 times when you download something onto your computer. You got to click through. Yeah, I agree to the terms. I agree to the terms, which frankly, none of us read. Now, as an individual consumer, there are some states where there's room to make an argument that, certain conditions may not be imposed on you, but if this is in the context of a business where somebody agreed to it, you're generally presumed as a business to be a sophisticated consumer and actor, and therefore you're going to be bound by those terms. So I've been droning on for a while here. So I'm going to let Gus get in a word about other types of contracts where we often see limitations like these.
Yeah, you see similar provisions in a sprinkler inspection and maintenance contracts. Obviously, it is a very risky business to, service and repair life safety sprinkler systems and their alarm systems. A lot can go wrong. It's a pipe system. Pipes can break. You can have property damage, water damage, And then if the sprinkler system doesn't respond in a fire, obviously the sprinkler company could be left vulnerable for claims relating to that fire. If the alarm system doesn't trigger properly, if the monitoring company doesn't catch a signal and notify the authorities, there's a lot of ways that a sprinkler company can be exposed to liability. And whenever there is a fire and there's a sprinkler system, there's a good chance that the sprinkler company is going to have to be involved in the origin and cause investigation, especially if there's an issue with some type of delay in the activation of a sprinkler head or the system. So they've made sure that their maintenance and inspection agreements are pretty ironclad, and you're almost always going to run into a terms and conditions that include some kind of limitation of liability. I recently came across one where it stated that even if a court finds that the company breached the agreement in any way, or a failure of the system was due to negligence or a failure of the installation or monitoring or repair service or any other service that the company could provided was related to the damage, any harm or damage to you or the property, the customer agrees that the liability shall be limited to the greater of $1,000 or 12 times the monthly service fee as liquidated damages, and that no other damages can be awarded. And courts have found that these types of limitations and damages caps are enforceable. This particular contract was related to a loss in Connecticut. Connecticut does have a gross negligence exception to limitations of liability, but unfortunately, most of these sprinkler inspection, maintenance, and repair contracts also have a subrogation waiver, and Connecticut does not allow for gross negligence to overcome a subrogation waiver. So, in those cases where you can even allege gross negligence, which is a tough standard, subrogation waivers would still be deemed enforceable in a lot of jurisdictions, including Connecticut. Moving on, also a lot of vehicle, trailer, large construction equipment rentals have terms and conditions that protect the renter. So if Penske, for instance, gives you a truck for your business, they usually require that you sign a lease or something, and that would include terms and conditions, and those usually include limitations of liability, subrogation waivers, as well as indemnification clauses. And sometimes the provisions will be a mixture of all of them. So, for instance, I came across an agreement, an equipment rental agreement recently, and it was titled indemnification. But if you actually read it, it was also a limitation of liability and limited any damages to quote unquote consequential damages. As Joe mentioned, very, very not clear as to what is a direct damage and what is consequential damages. And then we're going to try to speed along here, and we're going to move right into accelerated statute of limitations.
I see what you did there.
Thank you.
So this is a very important issue that really, as soon as you get the contract, you need to look out for this issue because a lot of contracts will shorten the period in which you can file suit. You may be thinking, hey, I have, the contractual statute of limitations in this state is 4 years or 6 years. I got plenty of time. But if you go through and read the contract, you have 1 year to file suit. Or you have to give notice to the other party within, 90 days of a claim arising. And, these are enforced and you do not want to miss a shortened statute in the contract, really. Otherwise, you're going to be putting your malpractice carrier on notice. So that's definitely a key issue. You need to review the contract very carefully to make sure that you don't have, an issue with one of those.
And just another note on indemnification and hold harmless provisions. Typically, those relate to third-party claims. So if a target or defendant raises an indemnification or hold harmless provision as a defense to your direct claim, it is very important to review the provision because most of them by definition of indemnification and hold harmless, is for it relates to claims made by third parties against either the target or the subrogor. So it might not apply to direct claims between the parties. Typically, it's related to third parties, not the signatories of the contract. However, you got to read it because sometimes there are limitation of liability provisions stuck in the indemnification provision, which could relate to first party claims between the signatories. But I've had many cases where indemnification provisions were raised as a defense to a first party, and then I provided sufficient law in that jurisdiction to show that that would not apply to direct claims against the signatory, and we were able to proceed and resolve the claim.
The next thing we're going to look at, there's kind of a checklist of items that you should check the contract for before you file suit. Even if you've read the contract a zillion times in the course of the claim, when you're getting ready to draft that complaint, file that suit, look at it again, because very often there will be a venue or forum selection clause that requires you to file suit in a certain jurisdiction. And that's generally going to be enforceable unless the selected forum has absolutely no connection to either of the parties or the contract. So you don't want to file in the wrong jurisdiction, have a motion come, and then, you look like a doofus to your client for not picking up on that kind of very obvious issue. Similarly, there are often dispute resolution provisions that you kind of have to jump through a number of hoops before you can file suit. Sometimes it'll be, give us 30 days notice before you file suit, and then the principals are supposed to engage in, good faith negotiations, and then you can only file suit if, after the 30 days and those efforts fails, or there will be a requirement for mediation or a requirement for arbitration, which Gus will talk about in a minute. But these are really conditions precedent to filing suit, and again, with an eye towards not being time barred in your claim. I mean, if you've waited and your statute is 20 days away, and then you look at the contract and you see that there's a requirement that you negotiate for 30 days, or you have to do mediation first, well, how is that going to happen in your 20 days before your statute expires? So, just additional kind of pitfalls and a little kind of mental checklist you should go through before filing suit.
Some contracts include arbitration clauses that you need to be aware of and certainly look out for. Going back to the AIA contract, Section 6.2 of A101 provides an option to select the venue or forum or type of resolution for contractual disputes, and gives you an option to select arbitration. If you do, then there's a set of requirements in A201, the general terms and conditions, and they include, if the parties selected arbitration as the method for binding resolution, then any claims would have to go through the American Arbitration Association, AAA, in accordance with its construction industry arbitration rules. It's very specific, and it could be problematic. It could be very expensive, and it may be the venue that you have to go through in lieu of litigation. There's the chance that defense counsel is not going to bring it up, and I've had situations where there was a clear enforceable arbitration provision that forced us to go to AAA, but we just proceeded with litigation because defense counsel never brought it up, and it didn't seem like defense counsel was interested in going into arbitration. I've also had cases where defense counsel explicitly stated that their clients are not interested in arbitration, as a dispute resolution for that matter. So we proceeded with litigation. So it's just something to keep in the back of your mind. As everything we stated today, as a wrap up, the main takeaways is to read the entire contract, because you never know where some relevant provision is going to be located. I have found personally subrogation waivers in miscellaneous provisions at the very end of the document. I have found accelerated statute of limitations in otherwise irrelevant areas of the contract. I know a lot of people open up a contract and go right to the insurance section and look for subrogation waivers and limitations of liability, but you could have an exculpatory provision in another area of the contract. Check who the signatories are. We've had cases where someone would cert a defense on the contract, but they weren't actually a party to the contract or protected under the contract. This could arise through, affiliates or subsidiaries not being properly named, or wrong entities getting identified as a signatory of the contract. And it could be an angle for you to argue. Was the document signed? Not always a way to invalidate the contract, but certainly worth asserting, especially, if if you're running out of arguments around the contract. And does the contract apply to subcontractors? That's something that you really want to look after, because if the liability theory is against the subcontractor and the contract does not explicitly apply to the subcontractor, then you may have an angle that any exculpatory provision in the contract between the building owner and the GC does not apply to the subcontractor. And if you have any angle to argue that a term is unenforceable, either because you believe you can prove gross negligence, or simply on a public policy argument, then it is certainly worth making. But the biggest point you could take away here is make sure you read the contract and you're aware of the issues that could arise. Thank you very much for listening to this episode of SubroSessions. Be sure to listen to the next episode of SubroSessions, which will be released on the third Tuesday of next month, November 21st, in this case. You could find past episodes of the podcast and relevant case updates on the Subrogation Strategist blog, all available at whiteandwilliams.com.